I hereby call the Elections and Campaign Finance Subcommittee to order. Clerk, open the roll. Please take your vote, and whether you're present or not, we'll wait on you, Rush. Don't rush. We'll wait on you. Please take the vote, Madam Clerk.
Mr. Chairman, you have 7 members present. You have a quorum.
Thank you. I appreciate that. Members, have you any orders before we begin? Any personal orders? Any announcements? All right. With that being said, today we have one bill on our calendar. Let me turn the page here. HB 0851 by Renault. We have motion and second on the bill. You want to tell us about your bill?
HB 851 brings into the law to be consistent throughout all parts of TCA statute. Current Tennessee law allows a U.S. citizen who was born abroad and has never voted or lived in Tennessee and has never resided in Tennessee to request a UOCAVA absentee ballot and vote in a Tennessee county based solely on where a parent would be eligible to vote. This means that someone with no residential connection to Tennessee can cast a ballot here, and HB 851 closes that gap. Today, 38 states require a UOCAVA voter to have been a resident at some point. Tennessee law does not require that. And while UOCAVA ballots are often assumed to be military ballots, over 76% nationally and over half in Tennessee are requested by non-military voters. This bill does not change residency law. It does not restrict military or overseas voters who are Tennessee residents, and it does not add any new qualifications. It simply restores a basic principle that our voting is tied to residency. This will pull it in line with our Tennessee Constitution, which says that for you and I as voters, we have to be a Tennessee resident to vote in our elections. And the UOCAVA ballot also says that an absentee ballot or UOCAVA voter also has to have lived in Tennessee. So it's just simply requiring anyone that's applying for that UOCAVA absentee ballot to meet the same residency requirements already found in the Tennessee Constitution and an existing statute.
You have an amendment to this? Your drafting code?
It is 012576.
That's what we have. To have a motion and a second on the amendment. Tell us, is everything you just said about your amendment?
Correct.
Okay. I do have one issue. What do you feel, excuse me, what, do we just have we need to go ahead and attach it before we discuss it? Has anybody got any discussions on the amendment? If not, we can go ahead and attach the amendment. All those in favor of attaching 12576 to the bill, say aye. Aye. Opposed, nay. Nay. We have the amendment on. Now we also have another amendment, my amendment. But before I call that up, I have a few questions about your amendment. I wanted to call Coordinator of Elections Goins up to describe that about your bill, if there's any issues with it, because I'm confused about a few things and what it does and doesn't do. There's so many things going around. Mr. Goins, could you come up and testify and tell us your name and title? Oh, we need to go out of session. Any objections? We're out of session.
Mark Goins, Coordinator of Elections for the great state of Tennessee. And
let me ask you, I had a question about Section 1G. What exactly does that restrict? Because I'm a little confused on it.
So I don't, and I've had the opportunity last year to spend some time with the sponsor. I know he's worked very hard on this, and I have a lot of respect for the sponsor. But the first sentence is language that we typically don't see. in state law. And it says a United States citizen who applies to register to vote by absentee ballot in accordance with this part must meet the residence requirements specified in 2-2-122 and the Constitution of Tennessee, Article 4, Section 1. And what's interesting is this says register to vote by absentee ballot. And so what I think this does, I think that this amendment goes broader than what the sponsor. Well, I don't want to speak for the sponsor. Maybe some of the advocates would want it to be this broad, but I don't think the sponsor would want it to be this broad. This also, because it doesn't limit it to folks who were born overseas, this would apply to folks that were born in Tennessee. And it appears to me that each time that person requests an absentee ballot, then they're going to have to meet the factors that's laid out in Tennessee Code 2-2-122. And those factors, typically a driver's license, owned property, various things. Well, by definition, there is a carve out, and this is a long-term carve out. It's a federal carve out. It's a state carve out. You have individuals who are born in Tennessee, but they go overseas. Missionaries, great example. Missionaries go overseas. They typically sell their belongings, and they're over there. Department of Defense in East Tennessee, particularly the Oak Ridge area, some in the Knox County area. When they get out of the military, they stay there, including military individuals who may have been overseas for a long time. So what it appears to me that each time this individual is attempting to request an absentee ballot, they're going to have to prove these residency requirements under state law. By definition, these folks are overseas and they don't meet those requirements. So this is something that is rare. I do want to clarify, 38 states, and I went to the FFAP side, and that stands for that's who assists military and overseas voters. And actually, if this amendment passes, it's going to put us in the minority, not the majority. There's 38 states that says essentially, if the parents were born in your state and there's someone born overseas to those individuals, then they're allowed to vote in that state unless they give up residency. What this amendment would do, it would put us with the 12 other states that essentially says, you're born overseas, doesn't matter your parents were Tennesseans, you're not going to be able to vote. In fact, I can't figure out where a missionary who has been overseas, say for 20 years, you've probably watched their children grow up. If you gave money to that missionary, you're getting that Christmas card. You're watching those children grow up. When that child gets 18, they're probably going to care about the election, particularly presidential elections. I can't come up with the way that that individual's going to be able to vote unless they come back to Tennessee and establish a residency. And that's not always the case. So that's really the status of, if this goes forward with this amendment, it looks to me you're going to be hitting the folks that are Tennesseans that aren't even born overseas, but it's certainly going to hit those folks that's born overseas as well. Like I say, I had extensive conversations with the sponsor last year. I'm not sure she meant to hit the military folks that had been living overseas for 18 years. But the way that I see this, if you're a military individual as well, so if you're the parent and you're from Tennessee and your last domicile was in Tennessee, I think you're going to have a problem voting absentee, which, by the way, would put us in conflict with federal law.
Also, there's been some statements, not by the sponsor to my knowledge, but by advocates for the amended legislation, that this is unconstitutional by the state of Tennessee, that the Constitution of the state of Tennessee defines residency. In fact, it's my understanding that it does not. It says that power is granted to the legislature to define residency.
That's correct. If you're looking to the Constitution, it specifically says as prescribed by the General Assembly. And if it is unconstitutional, then that means it's unconstitutional today. And it's been unconstitutional since 2004. It would also mean there's other areas of the law, like property rights voting, that would be unconstitutional as well. If you take the position that you as the General Assembly can't determine what that duration is, then you've got a whole. If it's unconstitutional in this scenario, it's going to be unconstitutional in a lot of different scenarios. Because as you know, if you have property rights voting, and I know you have some in Blount County, that's where somebody owns property in Blount County, but they may live in Sevier County. So they've never resided on that property. And if you take the position that what you're, that these individuals that's never resided here is unconstitutional, then property rights voting would fall in that same boat. They're the same concept. They're no different. So, and that's been around for several years as well. So I'm not a constitutional scholar. The General Assembly has given me the authority to authoritatively interpret election law for those who administer it. And I am an attorney. And so if this bill were to pass and I represented an 18-year-old child of a missionary, I believe the court would decide with me that the Constitution gives the General Assembly the ability to decide what residency is in this circumstance. I might be wrong. The court might disagree with me, but I think it's stronger. It's a stronger argument for someone to be enfranchised under that circumstance as opposed to disenfranchised. I mean, clearly, without a doubt, those missionary kids that grow up, military kids that grow up, if this bill passes and they've not established residence in Tennessee, they're not going to be able to vote. The quandrum they're in, typically their parents have sold everything. It is the exception and not the rule. These folks that's in the military, they get special treatment. Missionaries get special treatment, but they get special treatment because it's a special circumstance. They don't live here. They live overseas. And the federal level and at the state level, folks have decided these folks are U.S. citizens and they still get to vote in the state.
Do any have any questions from committee while we're out of session? We have legal here as well if there's any questions. All right, Chairman Moon.
Thank you, Mr. Chair. Ms. Goins, is there anything in TCA 122 that the situation you were describing with the missionary, can you give me something to point to there that would provide that, not exemption, but inclusion? Because, the legislature has spoken under that title and chapter as to what you need to do to establish residency.
That's right. And to be clear, she's changing existing law. And so you have those general factors in 122, and the legislature came in at some point and said, and part of it was to mirror federal law, but I don't want any misunderstanding. If her bill passes, in the aspect of allowing someone who was born overseas and never been in Tennessee, that would not violate federal law. What would violate federal law is if the parents who had been here would. But essentially what happened, the factors that's in 2-2-122, the legislature and even at the federal level have come in and carved out an exception because by definition, these people aren't going to meet residency. They're just not because they've sold their home. And it's an interesting concept that people have sold their home are still allowed to vote in the state. I get that. It sounds a little weird when you hear that, but then when you see that it's the person that's serving the country, or you see the person that's on the missionary, when you put a face with that, then you get it. And also, candidly, I don't think we're talking about a lot of voters here. I mean, the threshold, the ceiling that we had in 2024 presidential was 11,000 people that qualified to vote either military or overseas. We are dealing with a subset of that number. Unfortunately, I can't tell you what that number is. I did see an email that talked about, I want to clarify this too. There was an email that said folks coming from China that were having children here, you may have seen this email, and that the children would go back to China and then they would have those, the folks would be able to vote there. That's not what the Tennessee law goes after. Tennessee law goes after folks that are born abroad, not that's born domestically, if that makes sense. And just out of curiosity, I looked at Davidson County and Shelby County because those two counties were the largest and they had the information readily available. We sent 3 ballots in 2024 to China. So out of 2,000 ballots, 3 went to China, and that was it. I can't tell what the other counties because they couldn't get me the information fast enough.
Go ahead.
Thank you, Mr. Chairman and Mr. Goins. Really, that's a separate issue, birthright. That's an issue for another day. Your comment about owning property in Blount County or being able to vote in Blount County. I believe that's Maryville and Alcoa have that. The county doesn't, but the municipalities do.
That's correct.
I still having problems seeing clearly how we can get to these people being able to vote when they've never been in a period of time in the state of Tennessee.
Right, I get it. It's the parents. It's literally, we're shotgun on men with the parents. 38 other states have done this as well. I assume if you pass this, you're going to have a missionary at your church that's going to come in at some point and say, Sally that you've seen grow up is not able to vote anymore. And so that's the reason that you have unique circumstances, is because of these individuals. If I felt like that we were being taken advantage of, there's no way I would get up here and give this testimony. It is solely about those missionaries and military kids that I'm up here for.
Oh, go ahead.
Thank you, Mr. Chairman. I just worry about people that become expats and then decide that, well, maybe my child wants to vote, and they basically no longer even citizens of the United States. They've become expatriates, but yet the child wants to vote at 18, and that gives me pause. Thank you, Mr. Chairman.
So if I may, if someone has denounced their citizenship, of course, they wouldn't meet the qualifications. And there is a very important election integrity measure that Tennessee has placed on these individuals. And it is every year these folks have to sign under oath they still meet the requirements. It is a temporary resident, temporary registered voter. And federal law says the least you can go is 1 year. And, you can go more, but federal law says the least you can make these folks is temporary is 1 year. And Tennessee has taken that election integrity measure. So each time that individual seeks to vote, at least one time a year, they're going to have to fill out a new voter registration form. They're going to have to say they meet the requirements, and they're going to have to do so under oath. And that is where Tennessee gets it right. Tennessee is a strong election integrity state, and that's a measure that y'all have chosen to put in place.
Is this all overseas voters has to do this?
So you may have some overseas voters that's permanent residents. I don't want to get you confused, but if somebody is overseas and they're just there and they haven't sold their home or whatever, then I would probably be a permanent registered voter. I'm just having my ballot sent overseas. But if I qualify these specific subset of voters that we're talking about, where they've been carved out under federal and state law, then in every instance, those folks are signing up as temporary, and they have to do that every year. So come December 31st of this year, those individuals will expire. So they're no longer registered. They have to start back over in January. There's one exception to that 1 year rule. If there's an election in January or February, 90 days before the end of that year, then they can actually register in order to vote in the election in January, if that makes sense. You could actually, there is a 90-day toll if if there's an election going to be held and you'll be disenfranchised. But other than that, 1 year it expires, and I have a person in the office. We're very religious about notifying the counties that these folks are no longer eligible to register to vote. Next election, they have to fill out the forms and they have to certify they meet the requirements.
So again, in your expert opinion, as the amended bill is now, that amended bill would not only would affect these the children born overseas, it would affect military personnel themselves.
Yeah, absolutely. If you read the first sentence, literal interpretation. If you read it, you can see it with your own eyes. A United States citizen who applies to register to vote by absentee ballot. So each time they're applying to register to vote, which is kind of weird because you're already registered. But anyway, each time you're getting that absentee ballot, you have to meet the residency requirements of 2-2-122. And therein, this is a carve out. There's a carve out for these individuals because they don't meet 2-2-122.
We have Representative Leatherwood.
Okay. There we go. Well, you just kind of touched on my question there a little bit, part of it. But I was going to ask you, would you then say that this bill, as it's amended now, does it conflict with federal law at all? And would it, kind of reiterating his question, would it keep the military from voting in a broad sense or in a unique situation? Maybe they couldn't. Are you saying it would stop military overseas voting as well? And does it conflict with federal law?
It would, if has the amendment gone on? If the
Yeah.
The
amendment has
amendment is
gone-
on the bill, it makes the bill. so-
As amended, that first sentence would conflict with federal law because federal law is very clear. It says if you have established domicile in a state, no matter if you still have a residence there or whatever the case may be, if you're in the military, if you've established that domicile and you've not established domicile anywhere else, then you're eligible to vote until you change that. What this does, this sets a process in that every time you request an absentee ballot, you're going to have to say that you meet 2-2-122. And that's not what the current law is. In fact, most of these individuals don't have a house in Tennessee. They've sold that house. And normally that's a prime way to prove. It's not the only way. I mean, folks can rent, you can have a lease. That's evidence of residency. I mean, there's a variety of ways to do it. But the primary way to do that is either going to be looking at the lease. If you're in college, looking at a way to prove residency is to look at tuition statements, those things. So this basically says every time I request an absentee ballot, I've got to say I meet 2-2-122. And that's factors listed there that every voter has to comply with when they register to vote. And so it's actually the truth is, and I hate to say it's got to really respect this sponsor, and I've seen her in action in her district. I had the opportunity to go there for a town hall meeting. It actually puts more requirements on the military than it does you, in a sense.
Any follow-up or?
I'm turned back on again.
Okay.
If people saw me hesitating, I was waiting for the red light. Okay, I wonder if we could hear from legal on this as well, that might have a different perspective. It seems like, I know with $5 when they were at college, they were still able to vote. Is there anything out there, for missionaries getting support from this church and this district? But would you see that it conflicts with, this amendment conflicts with federal law, or would keep the military from voting?
Can you ask me the question one more time?
Yes. Do you see this bill as amended conflicting with federal law or keeping our military personnel from voting?
Yeah, I think it's possible because of the way that it's written. That says that to register to vote by absentee ballot, the federal government requires us to allow for absentee ballot voting by military members and people who are living overseas who are U.S. citizens. And this would require them to maintain some sort of residence in this state when they couldn't, because they're deployed overseas or they're a missionary overseas.
You mentioned it requires them to be a U.S. citizen. Would the federal law dealing with military, whatever, also require them to be a resident of the state in which they were voting, or does it give the state the ability to establish that?
I believe the residency would be up to the states to determine what the residency requirements for that state.
Does that include their children as well, their families?
Correct.
Okay. Any further? All right, we have Mr. Powell.
Thank you, Mr. Chairman. Sorry, I left to present a bill in another committee. I came back and we were talking about China, so I was confused. I have a question. So have you ever, Mr. Goins, have you ever found any evidence of non-residents registering by absentee under the current law?
Non-residents overseas, no, we've not. We have had folks domestically, not under these purview, not under the uniform, not under Yokava, not overseas. We've not identified anyone that's voted illegally. In my mind, voted illegally. I mean, we turn it over to district attorney. We have found individuals that domestically, Tennessee, where they may be claiming, we've had some dual voters. We've had some folks that voted in North Carolina and voted here. Obviously, they couldn't live in both. We've had situations where folks have claimed to live in one county. It didn't appear that they have lived in that county. We got a conviction there.
Okay. But pertaining to this, no. Would this change anything in your mind? I'm sorry, I stepped out for a little bit, but anything with the county election commissions would have to do? Any of their burdens if this bill passed?
So with the, yes, the burdens would be, so I assume that this would be litigated because there is a conflict where federal law says if these folks have established domicile, then doesn't matter whether they still meet the residency requirements. If they've established domicile at some point in Tennessee, until they establish domicile somewhere else, you've got to vote them. So this would take that away unintentionally. I do think it's unintentional, at least from the sponsor. But that there would be, when there's litigation, there's uncertainty, of course, about what's going to be enforced for the election. So we kind of deal with that anyway, in all honesty. I mean, we get sued from time to time. But in my opinion, someone would sue us fairly quick over this.
Okay. And I guess my last question is, could you contemplate a situation where, let's say, because I'm trying to think how this would actually be challenged. So let's say that it was a very tight election and there were 20 ballots that were cast in this manner. Could somebody then challenge the outcome of those ballots based upon whether or not the election commission had confirmed that those people were actually domiciled, or sorry, if they were actually residents? And if so, how would you even prove residency at that point?
So you got two different ways to bring litigation. One is the situation where the person can't vote. That's the disenfranchised. And that's the lawsuit we'd see right out of the gate. If there was a close election, absentee ballots is typically an area that someone will look at if they lose. Not necessarily overseas ballots, but they can, because you got to understand 10,000 spread out statewide. So, I mean, it's 11,000. I'm sorry, 11,000. So 11,000 sounds like a lot, but we had 3 million people voted. So you're always looking, it depends on how close the election is, but you're looking at from a standpoint of challenging an election, I'm looking at every single ballot. And that's one of the first things I'm looking at is absentee, whether there's enough military ballots in that district. I mean, perhaps in Clarksville, maybe Millington down there, in Shelby County or wherever, certain areas like that, but they're spread out other than Clarksville. So you could have a challenge on either end, contest of election, but you're peaking beyond, it would be very difficult to prove that person that voted through the Yokava was an illegal ballot. I would look for the lower hanging fruit, which would be the normal absentee ballots that you would get.
Right. But with this though, couldn't somebody challenge the election commission for not verifying that those people were actually registered before they requested the absentee ballot?
Oh, 100%. Now, sorry, I wasn't clear. I think the lawsuit even comes before it's a tight election. I think the lawsuit occurs soon as we tell someone they can't vote in the August primary or they can't vote in the November election. You're 100% correct. If we denied someone and it's a close election, then they too could come in and sue and say, you didn't count that ballot. And if you did count that ballot, how would it be? Now, the individual would have also had to try to ascend the ballot. It's not that's the problem you would have somewhat there. I mean, they might do that. I'll protest, say I'm going to vote a provisional. It'd be odd that they did that, but you could challenge it either way on the back end. That's correct.
Okay, thank you.
I want to, if a child of a military or a missionary or a State Department employee, anywhere, where they're born, that was born here, but was a baby when they left, and they want to, most of them visit family or visit their churches or something when they come back. And I assume even a young child has to have a passport.
I don't know if
I
they
would
have to have a
assume,
passport.
I would assume a
assume
passport is
that, but-
issued to all by the embassy nearby.
There's
get back in.
there's global travel, but I don't know how that ties in with with passports.
Anyway, I just say if they get a passport, that's a legal federal ID. But anyway, I didn't know whether that it made me think about that. But when we were talking about military personnel and missionaries and et cetera, that also included under federal definition. Does it say the soldier and their family?
So military, when it comes to if you're a dependent that lived in that state, then you're covered under federal law. The issue comes with these individuals who have never lived in that state, and that's what we're talking about. We're talking about that subset of voters who are U.S. citizens entitled to vote, but 12 states they can't vote in those states, and we might be 13 if this passes.
But regardless of those individuals that were born to families and achieved 18 over there and can vote, the family members, the military family member, the military soldier, and their family, what we have conflicts with law, not just that one family member.
Correct. I don't think that was the intent of the amendment, but the way the amendment is written, it would also hit those parents. I think the intent, and I only get this by talking to the sponsor last year, I think the intent was more geared toward the children that had never resided here. Unfortunately, it also hits the parents based off the language that, as it says here, each time they're going to request an absentee ballot, they're going to have to sign under oath that they meet 2-2-122. And that is the general requirements for registering to vote. It's also, by the way, if you're running for candidacy, it's what we look for. If somebody challenges a candidacy, it's what we look for as well, to see if someone has established residency in those areas. By definition, once again, these folks don't have a traditional residence because they're overseas. I mean, I guess you could be wealthy and maintain multiple homes and problem solved, if you still had a house there. But in many instances, particularly those missionaries, and by the way, this is an educated discussion as well. Just a little history. Chairman Rudd put me in contact with someone who works with missionaries in Tennessee, and I spoke to him, and he unequivocally said that this would disenfranchise missionary children. Unequivocally said that. And that was a conversation that I had. I also spoke to my brother, and from a personal standpoint, my brother-in-law, this is what he does. He sees missionaries all across the country. I spoke to him, and he said, Mark, it's so hard for missionaries to vote now. He said, this is just going to intensify it. And a lot of these folks do go over there, and they do stay. Fortunately, the legacy of those parents is to spread the gospel of Jesus Christ, or whatever it may be, whatever religion they are. And so they may never come back to Tennessee, but they're still Tennessee. If you ask them, I mean, that's where they're from, right? So, I mean, that's what you're talking. It's a very difficult issue, and I understand it. On one end, you got the soundbite, and the soundbite is these folks have never lived in Tennessee, but they can vote in Tennessee. It's a horrible soundbite. But the truth is, when you see these people and you know their story and you know the reason they're overseas, then you get it. It's not like they're not Tennesseans. I mean, they had some kind of connection to Tennessee at some point, and that connection was their parents were domiciled here. They were here. It's not like they were from Kentucky. They were here. So that's the distinction.
All right. Any other questions? Oh, Mr. Bricken, I'm sorry.
Thank you, Mr. Chairman. First of all, I have great respect for Mr. Goins and our sponsor on this issue. I'm still leaving myself a little bit deeper confused as we go with the discussion. And I would, not sure what the protocol is, I would like to keep Mr. Goins either available. I'd like to go back to the sponsor and let her talk about some of the issues that Mr. Goins raised, and then possibly go back. And then at the conclusion, I wouldn't mind rolling this bill for a week for those two to get together and see if there's not some mutual compromise. But I'd like to hear some discussion before I think that is where we need to go with this.
Well, based on what you've recommended, unless there's any objections, we will go back into session, ask Mr. Goins to stay, because there's also a second amendment coming up that he may need to comment on if we get that far. But we are back in session. Mr. Bricken, you wanted to talk to the sponsor?
Thank you, Mr. Chairman. Yes, sponsor, Mr. Goins raised several issues about disenfranchising military or making under, and I don't know all the issues of 2-2-122 that would make it virtually impossible for a child of an overseas Tennessee citizen from ever claiming residency to be able to vote. But you've heard what he raised. I would like for you to comment.
Thank you. I'd be glad to comment. I think first what I would like to do is clarify this amendment. And I'd like to read what is currently in the code, which is Section G, which is what we're changing. The current code says a United States citizen who was born abroad and who is eligible to vote and who has never lived in the United States may register temporarily and vote in the county where a parent would be eligible to temporarily register and vote pursuant to this section. The amendment is changing that to bring our code in line to be consistent with the Tennessee Constitution, which I will go to here now to read to you, that says every person being 18 years of age, being a citizen of the United States, being a resident of the state for a period of time as prescribed by the General Assembly. So yes, the General Assembly can prescribe the time that you can, and we have. All you have to do is go and register, and you can be eligible to vote within 30 days, assuming you've registered in time, or you can be able to vote immediately, actually, as long as it's 30 days before the election. The section that we're amending is G, but the section A above that applies directly to the military overseas voters, and it says specifically that application to vote absentee by mail from armed forces personnel anywhere outside the country, where the voter is outside the country, where the voter is registered, or from qualified voters temporarily staying outside the territorial limits of the United States, et cetera, shall be processed under this section if it does not meet the requirements of 2-6-202 as an absentee voting application, or if the applicant is not a registered voter. So we are not touching the military aspect of this. And I'd like to point out that when you apply for a UOCAVA ballot, there is no proof that you have to provide. It is a personal attestation that you are giving that you're a Tennessee resident or military or whatnot. We are trusting the person's word that when they submit that ballot that they live, or that they're a citizen, or that they live in Tennessee. So we don't have any requirement for them to show proof. We're not asking to go as far as for them to show proof. We're asking them to make a personal attestation that they, according to this amendment, meet the guidelines that you and I have to meet in 2-1-222, whichever it is. Let's see. So you and I have to live in the county at some point, and we're asking an absentee ballot to testify that they have, in some way, shape, or form, lived in this county and have some residency at some point. What I'm concerned about that we're doing here is that we're trying to remove the tie that the Tennessee Constitution has to residency and make it to ancestry. That's just not what we do. Our Constitution doesn't allow that. Voting rights have never been inherited. They're not transferable through a parent's former residence either. I would like to point out that there are 4 states right now being sued by the RNC for allowing a non-resident to vote in their elections. That includes Michigan, North Carolina, Arizona, as of yesterday, California. The RNC is suing these states for allowing a non-resident to vote. By passing this amendment, what you're doing is it's making our code consistent with the Tennessee Constitution to say that we don't want a non-resident to vote in our elections. I certainly have compassion for somebody who's maybe born abroad and has lived overseas for 18 years, but every missionary that my family has supported, that we go listen to our church, they come back once a year. They have plenty of time to come back, to register to vote, to do whatever needs to be done to establish residency. And I would probably question, if someone hasn't been here for 18 years at all, why do they want to vote in our elections? But that's beside the point. We do have a way for them to do that.
Mr. Bracken?
Just for clarity, that 30-day window or for them to come back and register, do they physically have to come back? Or can any of that be done remotely?
Register to vote in a county that you've never lived in?
Well, if I heard you correctly, you said these overseas children or whatever could come back or could register 30 days prior to an election by just attesting that they are still citizens of our state. Is that correct, or did I hear that wrong?
Go ahead.
What I was saying is that you and I can go and register to vote and we could move and register the next day to vote, and that you would be qualified to vote in the next election as long as you have done that 30 days prior to the next election. That is the rules that you and I fall under. And so we're just asking in this amendment for an absentee UOCAVA ballot holder to fall under the same requirements, that they have at least lived in the county at some point, been a Tennessee resident before they apply to vote as a UOCAVA voter.
Go ahead.
So they would have to come back and have a residence temporarily or whatever. But I don't know what, it's once a year to register.
Sorry, maybe you misunderstood me. I was saying that I know that most missionaries come back,
Understand.
once a year. And so they have time to do that, if they needed to register to vote, if they needed to do something to establish residency. If they're a child of a parent, then they do, by our 2-1-222, they do qualify to vote because they are usually, residing with their parents if they happen to still not be out from under completely emancipated for whatever reason. So if for a UOCAVA ballot, they don't have, there's no, as far as I understand, there's no registration process. They just apply to get one.
Go ahead. Are you done? Anyone, any other questions of the sponsor? Was Representative Brick, okay. Representative Brickett had asked for Goins, Coordinator Goins to come back up to respond, but we have a request to speak from Vice Chairman Wright.
Thank you, Mr. Chairman. Let Representative Leatherwood be in front of me.
Okay. Representative Leatherwood.
Thank you. So first, I appreciate Representative Bricken's thoughts and approach and suggestions on this. But in your conversation, you're talking about, and it's something I've brought up to people as well, missionaries I know come back at least once a year to gather support and so forth, maintain support, get new support. And you mentioned they could register to vote. What would they have to do to register to vote? Do they have to buy a house? Do they have to rent an apartment? Do they just say, my children went off to school, they were still able to vote in our home, but it's based on the home my parents had. What would that overseas person have to do in order to register to vote? One, and then two, an important part to me, I've heard that this would interfere with the military's ability to vote overseas, which I do not want to do. You have said it would not interfere with the military's ability to vote overseas. I don't know if I felt settled at one point, but I don't know if legal, on reflection, really said something definitively on that. But first, what would that child of missionaries or military have to do when they come back for that 2 weeks or something to maintain support? What would they have to do to register?
2-2-122 states what they can do to qualify as residency. And so if the parent is residing here, that would be a way that they would qualify. If they are over 18, they're likely going to get a driver's license, so that would qualify. Any kind of taxes that might be paid, purposes of their person's presence in a particular place. My understanding is that usually it's the totality of your circumstances that can determine your residency. But if they're pulling a UOCAVA ballot, they're doing none of those things to indicate. But if they really do want to vote and they're coming back here every year anyway, there are many opportunities for them to secure residency for the purposes of voting. And, again, if their parents are here, they're coming back here, there's likely some place that they have official mail going to that would qualify. The law is very clear that as long as they have an intent to return, they would qualify to be for their separation from here to not disqualify them from voting.
So you
Go ahead.
say if they have intent to return, so someone overseas, they could just, at the election commission, sign some intent to return to Tennessee form, and it could be as simple as that for them? to register or?
So the 2-2-122A1 says the residence of a person is that place in which the person's habitation is fixed and to which whenever the person is absent, the person has a definite intention to return, provided that a person may not register to vote using a business location as the registration address when the sole basis for the person's presence at such location is based on a business or commercial use. So if they come back and again, their parent likely has some sort of official place that they are obtaining mail, that they're registered, then they would be able to use that address to register at that point. I think there's plenty of opportunities if you really want to vote to pursue that in a way that honors everyone else's vote, that it doesn't dilute our vote for those of us who have followed this requirement.
Yeah. Vice Chairman Wright.
Thank you, Mr. Chairman. I am now nothing but filled with questions or uncertainties. And some of my uncertainties come from the advice that this would certainly place us at odds with the Fed. And then, not speaking of the committee that we're sitting here on, we may eventually today take up an untimely filed amendment. Continuing on, some of the members, and I've been involved in this discussion for a few days, but there's extreme amount of rushing around, and maybe some of the members didn't even really get into depth on this until an hour ago. And then again, I heard another, we're going to have a lawsuit. And then I heard the word unequivocal. And then I heard most missionaries once a year. That sort of reminded me of something that we were doing on electric vehicles earlier today, and it's a word we've got to go back now and fix. Military folk may have a long tour assignment and may not be back in the United States for 4 years. There are so many questions that I think have been brought to the table today, and we may be running ourselves short on time. I don't want to place this committee in a position of dealing with stuff that's going to be uncertain. So I hate to be blunt, but I probably only see a couple of ways out. One, that the action requested today is denied, or that we be given a couple of weeks to see if we can fish our way through this to get what you need to be done within acceptable by the committee. Because right now I've got too many little things hanging on to me that would not allow me to place this in code questionably. I mean, without we got to come back and fix something. So if I were to offer a request that maybe you take a couple of weeks for us to work through this, would you be agreeable to that? Mr. Chairman, what's the technical stuff we have to do to say roll this 2 weeks?
Well, if I'm not, please correct me if I'm incorrect between the research and the law. Since you've made the statement, you can't make the motion.
No, I'm asking you a question. What do we have to do?
Yeah, if you wanted to roll it a week or two, then either the member can personally request it at the podium or a member can make the motion and second it.
Thank you, Mr. Chairman.
Request to roll this for 2 weeks.
Any objections? Rolling the bill to 2 weeks. Seeing none, 851 is rolled for 2 weeks. Oh, well, we're off now, but
I know. Can we ask Mr. Goins and those to get together?
yes, well, we're not technically adjourned yet, but yeah, we can't do any more of the bills gone, but yeah, they can get together. And by the way, let me make this clear. He's been accused of getting involved in this. I called him to ask his opinion. He didn't volunteer it. So I was worried about missionaries and the military when I read it, and I was confused over it. And I said, I don't know, because, I told you last year in concept, I agree with the bill, but it's got some oddities. You tried to fix that, but now I think it's created another question. And yeah, by all means, get together and get together with me and let me know. I think that the upcoming piece of paper, mine was going to basically fix that and put a little bit more teeth into it. But yeah, please get together. And have any objections, we will adjourn. Seeing none, we are adjourned.
Mark Boyd used to be the president, the chairman of our Business and Utilities Commission, Subcommittee. But he's now moved on. He's now the House Majority Whip. He just went into caucus leadership. So he's from Lebanon, and whenever I mentioned her name, he went, ooh. He's developed some townhomes there for it, and he just said, man, that's hard to deal with. And so it's not productive. So that's going to be. Their corporate boundaries. They tend to, they don't have to be easy to play along with, and they're, especially whenever there's some scarcity involved, apparently. That's what we got to get I think we need to focus on that. What it is that they're protecting. My question for you is among those other, what are we looking at rough order of magnitude for pump increase, size increase, or improvements, and maybe some line improvements? Because I'm trying to think of, is there what?
Right. So, and Edgar, you can budget underwriting for infrastructure improvements to bring sufficient service to the site. We're carrying that